I'm Kevin Foy, one of the torts professors at North Carolina Central University School of Law. In this video, I'm going to introduce the tort of false imprisonment. False imprisonment has its roots in a time centuries ago when it probably literally referred to unlawfully putting someone in prison. However, the law has expanded the scope of this tort over time, and today false imprisonment is more broadly seen as protecting a person's interest in being free from restraint. One definition of false imprisonment is that it is the intentional, unlawful restraint through force or threat of force that confines someone to a bounded area, and the person is either aware of the confinement or is harmed by it. Let's break this down into the prima facie elements of false imprisonment. False imprisonment is an intentional tort. As you know, the common element that ties all the intentional torts together is that plaintiff must show that defendant acted with intent. This requires that you employ the legal definition of intent that you have learned. The second element is that defendant's conduct be unlawful. In this context, unlawful means unconsented or unprivileged. We'll talk about privileges in more detail later, but for now, you should recognize that a plaintiff who agrees to be restrained has consented and therefore cannot bring the claim. You will see in the cases you read that what might constitute consent goes beyond simple verbal agreement. Also, if a person has the authority to restrain the plaintiff, a person such as a prison guard, for example, then plaintiff cannot bring a claim because the guard was privileged to restrain the person. The third element is force, or threat of force. To satisfy this element, plaintiff may show that defendant physically forced the confinement, but it is also enough to show that defendant threatened force, and that the threat was enough to intimidate plaintiff into compliance. It may sometimes be difficult to distinguish what a reasonable person would consider was sufficient threat of force versus whether the plaintiff has voluntarily agreed to be confined, and that will be fleshed out in your reading and discussions. The fourth element is confinement to a bounded area. Here is where the tort has expanded beyond its origins. Because this tort protects a person's interest in being free from restraint, confinement means more than simply locking someone in a room. So, for example, a plaintiff could be imprisoned in a car, even though the doors are unlocked, if the driver refuses to stop and let the plaintiff out. Plaintiff could even be confined to a bounded area in the open streets of a city. The key is that defendant sets boundaries. One thing to keep in mind about this element is that it requires total restraint to the bounded area. So if defendant blocks plaintiff's passage in one direction only, and plaintiff can go another way, then it is not a bounded area. Similarly, if defendant shuts plaintiff in a room, and there is a reasonable exit available, then it is not a bounded area. The last element is that the person know of the confinement or be harmed by it. This element reflects the purpose of the tort, which is to protect a person's knowledge that she is free to move around. If she's not aware that she can't move as she pleases, then there is no real interference that the law recognizes. So a person who is not conscious at the time of confinement cannot fulfill this requirement. However, the person may be able to show an alternative, which is that she was harmed by the confinement. Harm means physical harm. So a plaintiff, even if unconscious, who suffers bruises on his wrists as a result of being tied up and locked in a room, can satisfy this element. In your reading, you will also encounter references to false arrest. False arrest is similar to false imprisonment. The distinction is that with false arrest, the defendant, such as a police officer, asserts the legal authority to take someone into custody. Sometimes police officers do have legal authority to restrain someone to a bounded area. But if the officer does not, then the arrest may be false imprisonment. Finally, you will notice that there is no element of damages in the prima facie case. False imprisonment may be maintained without showing proof of actual damages. That doesn't mean most plaintiffs don't claim damages. Instead, I'm pointing out that damages are not an element of the prima facie case. This is because the damage to the plaintiff is in the action itself, the restraint. So the law presumes damages once the elements of the case have been demonstrated. In summary, false imprisonment is the intentional, unlawful restraint through force or threat of force that confines someone to a bounded area, and the person is either aware of the confinement or is harmed by it. I hope this video has helped you learn and think about the tort of false imprisonment as you read and discuss the cases.